Hello, I'm Jessica Ryan Keeney. I'm a family law attorney. I'm licensed to practice law in the state of California. I'm also the Department of Child Support Services attorney for two tiny Northern California counties. So this is a video, all of my videos apply to California only, unless I state otherwise in my video. At some point, I'm probably going to take the Oregon bar, and who knows, maybe I'll start doing Oregon videos at that time. But anyway, right now, California only. That's the only place I'm licensed to practice. So my videos are not intended to be legal advice. They're for educational purposes only. If you have questions, you can put them in the comments below. I'll do my best to answer them. My answers still are not legal advice. They're still educational purposes only. Basically, I'll tell you, how I've seen other people handle the situation mentioned, how I've handled it. It does not mean it's the best way to handle it in your case. It's your responsibility to go hire an attorney or make your own legal decisions to figure out what's best for your case. Anyway, that being said, these videos, any opinions expressed are my opinions only. They do not reflect the opinions of my clients. And this is part 2 of a multi-part video that is supposed to be a brief outline or overview of a parentage, also known as custody and visitation case. So, again, in this video, I talk about the children, I talk about mom and dad. The overview is the same, whether it's 1 children or 5 children. It's the same whether it's a mom and 2 moms or 2 dads. I mean, there's usually other details if it's 2 moms or 2 dads. I mean, no disrespect to any other family structure, but I'm going to talk about the children and mom and dad for purposes of my video. So in video 1, we discussed opening a case. It was mom who opened the case. We discussed getting dad served. We discussed getting a court date, going to mediation, going to court, and getting a court order. So now what happens if dad gets served, mom and dad already have an agreement, or they reach an agreement? What do you do? So you can still get your court order. And in fact, I highly recommend getting a court order because you just went through the hard work of reaching an agreement, and we want this order to be enforceable. Hopefully you'll never have to have it enforced, but you went through hard work. You might as well come out with an enforceable order. So what you do is order, and I list the documents in the outline on my webpage. There's a link to my webpage in the description below, and if there's enough room in the description, there will be a link to a bunch of documents below. If there's not, then go check out the outline on my webpage. Anyway, so you're going to do a stipulation and order, and you're going to do an advisement of rights, and there's likely going to be at least one, possibly several other custody attachments on that stipulation and order. Mom and dad are going to put in there what their agreement is. Okay, and that agreement can include child support as well, but I'm not covering when the agreement includes child support in this video. I'm just doing custody and visitation. So mom and dad put the terms of their agreement into all these judicial council forms. Judicial council forms are forms that are used statewide. Some counties have local forms that also need to be used, so go read your local rules to see if your county requires any. You'll also have access to those local forms on your county's website. But anyway, so you fill out those judicial council forms. Mom and dad need to sign the stipulation and order. The stipulation and order doesn't say that mom and dad need to have their signatures notarized, but any party who is not represented by an attorney and isn't having their attorney sign a stipulation and order also needs to have their signature notarized. We don't really do this in child support cases through the Department of Child Support Services, but all my private cases, we do this. And this is so that it makes it difficult for somebody to come back later and say, I didn't sign that form. He or she sent the neighbor to sign on my behalf. Okay, so by having the signatures notarized on the stipulation and order and attaching that notary acknowledgement, it gives a level of authenticity to the signatures. So you get your forms filled out, you get them signed and notarized, you get them all assembled to file with the court, and one of the parties is going to take that stipulation and order to court and have it filed. There's going to be a filing fee because you've got to pay a filing fee to get the court signature, but I think it's well worth it so that you end up with an enforceable order later. That stipulation and order is going to go to court. The court might need to mail it back to you later. They might sign off on it on the spot. You might come back in a couple days and pick it up out of a box or a file bin. It can be different in different courts. Anyway, so find out when you file this document with the clerk how you're going to get it back. Take an envelope with enough postage that the court can mail the endorsed documents back to you if they need to. And if this is your first order in the case, you're also going to need to do your judgment documents. There's a whole bunch of documents that go along with the judgment documents and the stipulation and order. So I discussed that in my outline. As of filming this video, my outline is being edited by a friend, so might not be on my website until a couple days after this video posts. So make sure that your stipulation and order includes that both parents are indeed the parents of the children, and make sure the judgment includes an order that both parents are the parents of the children. This often seems ridiculous to people. I'm mom. I gave birth to the children. Of course I'm the parent. I'm dad. I'm on the birth certificate. I signed a voluntary declaration of paternity. Make sure that you go through the forms, check the proper boxes, and get an order that says that the parents are the parents of the children. It'll make life easier in the end. Okay. Oh, yes. So what happens if back at the beginning of the case, dad gets served, or, like I said, it applies if it's dad who opens the case and it's mom who gets served. But let's say that dad gets served with the summons and petition and UCCJEA and doesn't file a response in the case. Well, mom has to give dad, or the petitioner, who's the party that opened up the court case, has to give the respondent, that's the party that gets to respond, 30 days to respond. Okay, so that 30 days is really more of a restriction on the petitioner, which in our example is mom, than it is a requirement on the respondent, which in our example is dad. So to me, saying petitioner has to give respondent 30 days to respond means petitioner can't file for default until day 31. But, petitioner waits 60 days. It's not the end of the world. And so basically what happens is respondent, in this case dad, is given the 30 days to respond. He doesn't. Mom files the default documents, which is, I've got the documents in the description. It's going to be a declaration for default or uncontested parentage action, as well as a request to enter default. Names might be slightly different, but that's more or less what it is. Okay, so mom can only get, or petitioner can only get, if the case proceeds by default, what she asked for in the petition. Or mom and dad can reach an agreement and dad doesn't have to respond. And so those are the two ways that you can get an order if the other party doesn't respond. And so along with your default documents, you're going to need to do your judgment documents. And if there is an agreement about custody and visitation, you're going to do your stipulation and order. So some people open up these cases knowing we've got an agreement and the other party isn't going to respond. And this is just the strategy to open the case, get the stipulation and order and the judgment documents filed without the other party having to fill out any documents, respond, whatever. Basically, the other party just has to sign the stipulation. So something that I see a lot of people forget in parentage actions is once they get that order, whether it's a findings and order after hearing or it's a stipulation and order, they forget to get a judgment. And it's not necessarily the end of the world, but it wraps the case up in a nice little package if you get the judgment. And if you do the request for it to enter default and the stipulation in order, it makes sense to get the judgment. Let's see. What else was I going to say? Oh, yeah. Be sure, again, I can't stress this enough, that your order, stipulation in order, your judgment say that mom and dad are the parents of the children. Okay, that was my brief overview of a parentage case from start to finish. Keep tuning in for more content. If I don't have the outline on my webpage right now when you're viewing this, come back later, you'll see it eventually. I might go ahead and post the unedited outline just so that everybody has something to look at. So if you find mistakes in it, sorry. You can put a comment below and let me know what they are. I'm prone to spelling and grammar errors. That's just me. So yeah, thank you. Let me know what other videos you would like to see. And remember, click the thumbs up button, subscribe, leave some comments.